To join us for this really important and timely panel. I'm Dr. Sara Farhan. I'm a historian of the modern Middle East, and I'm privileged to be with you today to moderate this panel. Thanks to the behemoth efforts of Karen Rodman for putting this all together. A lot of work goes behind the scene, and we're grateful to you, Karen, for your unrelenting effort and support. So thank you so much. We're here today to discuss Canada's and just terror lists more broadly. Canada's terror list started in 2001 as part of the Anti-Terrorism Act, Section 83.05 of the Canadian Criminal Court. Canada began compiling a list of group names with little to no explanation of the compilation processes. This, of course, highlights one of the many consequences and the global impact of 9/11. These lists are compiled by the Minister of Public Safety and Emergency Preparedness. There are, of course, serious concerns about this list, most of which are rooted in the instrumentation of state violence and vague definitions and limited transparencies of such processes. The terrorist designation lists are problematic because, of course, of a litany of reasons, but there's no internationally accepted or universally framed definition of terror. If anything, these lists have the potential of acting as accelerators of tension. The criteria for designations vary, and when examined closely, they reveal political motivations with deliberate vagueness, perhaps to obscure national security in order to cast wider nets. There are also no procedures for challenging these designations, which, in my opinion, are fundamental to any democracies or rule-based societies. To give you an example, Mandela paid 3 visits to Canada after his release and was granted an honorary citizenship in 2001. But this was, of course, delayed because Saskatchewan MP Rob Andres of the Canadian Alliance refused to vote for, quote, a former communist and terrorist, end quote. 4 years ago, this list grew even bigger because the then Minister of Safety and Preparedness, Bill Blair, added 13 new designations. This, of course, highlights the racial dimensions of the attribution of the title of terror. He was a former chief of Toronto Police, who's now currently our Minister of Defense. Blair, of course, was questioned about the recent drone exercises that took place in Alberta last, I believe it was in June, to which some of the MLA members were concerned about Israel's participation, and he defended his decision relentlessly. He was unwilling to kick, essentially, Israel out of participating. Of course, I don't need to remind you about Bill Blair's G20 summit response and the class action suit against his response, which I think it ended in August 2020 as well. So he is currently the Minister of Defense right now, and this is part of the convoluted package that we're dealing with today, and this ever-growing confusion and vagueness, again, perhaps deliberately, regarding the definition and designations of terror. So with us today are panelists who are legal practitioners and scholars with a vast array of expertise, including human rights, civil litigation, prisoner rights, and of course, criminal law. We'll begin with Yavar Hameed, human rights lawyer and community advocate, part of Hameed Law, which is based in Ottawa. Who will then be followed by Shane Martinez, criminal defense and human rights lawyer, and a legal. And Tim McSorley will conclude the panel, Tim is the national coordinator of the International Civil Liberties Monitoring Group. So thank you very much for taking time and joining us today. Yavar, please go ahead. Thank you.
Thank you so much, Sara. It's an honor and privilege to be on this panel with my esteemed panelists on this very important topic of how listing under the criminal code of terrorist entities actually propagates Israeli terror. My link into this question is acting as counsel for the Islamic Relief Fund for the Afflicted and Needy, IRFAN Canada, for about a decade, from 2011 onwards. In the course of acting as counsel for IRFAN Canada, it received notice of revocation of its charitable status, IRFAN being at the time, back in around 2010 and previously, a well-established Muslim charity that provided relief to humanitarian relief to war-stricken areas, including Gaza and the occupied Palestinian territory. And because of that, in that context, there were allegations for about a decade, starting under the conservatives in about 2003, 2004, about Irfan Canada being a front for Hamas. Those were unsubstantiated allegations, but they circulated for a period of several years, causing the organization to go under audit by the Canada Revenue Agency. It underwent 2 audits, which it substantially defended in terms of its books and records, while delivering aid to Gaza, who, as everyone will know on this call, is even prior to the latest bombardment, was just being really devastated by the blockade, by restriction of assistance. And Irfan Canada was one of the few organizations that was providing relief to it. At the time when it was fighting its second audit, and this would have been in 2014, in the course of raising our arguments before the Federal Court of Appeal, Irfan Canada was listed as a terrorist entity. This came as a shock to us, but it also wasn't shocking in a way. It came as a shock because we were involved in a process, in an adversarial process under the Income Tax Act to basically rehabilitate the status of a charitable entity. But in the course of that, this very entity, which only months before was giving charitable assistance, was overnight transformed into a terrorist entity. That was so surprising because leave aside the fact that we knew that part of the basis for Canada Revenue Agency's attempt to revoke the charitable status of Irfan Canada was secret orders and investigations by the government of Israel against Irfan Canada through processes which, some of us might talk a little bit more about how Israel systematically violates the rule of law and fairness in terms of how it incarcerates Palestinians and extracts information. That information then becoming the basis of an audit of a Canadian charity, which then uses the same information collected by the Canada Revenue Agency to become the basis of an RCMP, investigation for the listing of this organization as a terrorist entity. So what did this mean? What were sort of some of the lessons learned by this listing? And I'm going to distinguish, what the organization Irfan Canada went through, as opposed to the context of what now we're dealing with, grappling with in the aftermath of Samidoun's listing, because Irfan Canada was a charitable organization receiving charitable donations, receiving charitable gifts from not only the Muslim community, from the Arab community, from people across Canada. And there were established lists, networks of supporters who were giving money. And the whole lifeblood of this organization was to rely on its goodwill and to be able to deliver its humanitarian assistance in the region. By virtue of that listing, overnight, all of our efforts to try to have the charitable status revoked just became effectively moot, because now the organization didn't exist. It didn't have the right to transact any kind of financial measure, to receive donations, to do anything in its own name. To elaborate a bit further on that, even in the course of our attempts subsequently to try to delist Irfan Canada, and we were not successful in that process, and they sort of ended prematurely, for one thing, because it is not only a criminal offense for someone to donate or give money to the organization, but there needs to be special dispensation for any reason for someone to even act on behalf of that entity and to be receiving money for that purpose. And to that end, specifically as the lawyers and the legal team for Irfan Canada, we sought special permission or dispensation from the Attorney General of Canada to be allowed to get money for legal fees, for legal support. We were denied that. We went to the federal court and we tried to get advance costs because really we were blocked. Otherwise, advance costs means we're a special request to have the government fund the challenge to the listing. The federal court denied us. And so a lot of the procedures that we used in this adversarial process to try to get Irfan Canada delisted were just met with roadblock after roadblock. In terms of what the listing of Irfan Canada meant for Muslim communities throughout Canada, and everyone who was supporting it throughout the world, was that those networks potentially became subject to, they did become subject to scrutiny at a certain level, because all of the books and records of Irfan Canada ended up in the hands of the RCMP. Now, as a point of fact, I did not learn of specific RCMP investigations leading to criminal charges against anyone that was affiliated with Irfan Canada, but that does not mean that there was not persons of interest, there were not networks that were being looked at, and the specter, and this is really, really significant here, the specter of association with Irfan Canada for people who were legitimately interested in supporting the humanitarian efforts, particularly in Gaza, but throughout the world, because of that scrutiny, no one obviously donated, but they distanced themselves from that organization. And so the effect had been achieved. The financial crippling of this excellent humanitarian organization delivering aid had just been crippled overnight. So I think that part of what Shane might speak to as well from a criminal law perspective that is so odious about the listing is that there is no adversarial process whereby there's a case that the organization has to meet in order to or rather for the government to meet in order to substantiate the basis of the listing. The government can simply list, and then the onus shifts over to the listed entity to become delisted. And for so many reasons, this is offensive because it's basically a fait accompli that there is some reasonable basis already for the minister to have listed that organization. So presumptively, one may feel or one may have the impression that there's something really legitimate there. But as I've noted, a moment ago, a lot of this, the intelligence, the information that was assembled for this, laudable charitable organization was collected by unlawful means from Israel. There was a case in the United States known as the Holy Land Foundation case, which was a very prominent case where there was sort of a network of linkages where the predecessor to Irfan Canada was sort of, insinuated to be part of this network of unindicted co-conspirators. And so the team, which is not that term, which is not even cognizable in a Canadian context, just laid suspicion on Irfan Canada coming from the United States, based on a lot of secret intelligence coming from Israel, which we know was tainted by being obtained through unlawful means. What it came down to at the end of the day, and I think this is really significant, and I'll probably end off on this and a related point, is that the fact that humanitarian and material assistance, about approximately $13 million of the $14 million that was alleged, I would say probably closer to between 11 million dollars. We detail all of this, and if anyone wants details on this case, it's all in our factum. Was actually medical supplies, We're talking about dialysis machines. We're not talking about weapons of destruction. Beyond that, there was a double count of some information, but beyond that, for about $1 million, we're looking at support for orphans, support for underprivileged children, just truly humanitarian assistance, which, because of the fact that it was in a Hamas-controlled area, there was guilt by association that this organization was an arm, effectively, of Hamas. Now, I think the efficacy, and I would say I'm using the perverse efficacy of this tool, is that guilt by association works. That part of the basis of the listing is that the reasonable grounds to believe that this organization is acting, in concert or to advance the interests of another organization. And so we're not even really talking about the activities of the individual organization. We're literally talking about guilt by association. Now, when it comes to Samidoun, what some of my other co-panelists will probably talk about is that we're not talking about a listing of a charitable entity who, for all intents and purposes, is done the moment it's listed. We're talking about the listing effectively of a grassroots organization that didn't have the stature, the funds, anything of the nature where one would think that the state would have an interest in sort of attacking its financial mechanisms. And so in this context, one must wonder really what's at the root of it. Once you make this organization, Samidoun, which is involved in what was involved in prisoner justice, in solidarity networks in Vancouver and throughout Canada and beyond. Once that entity is criminalized, it raises the specter of criminalization of things that are adjacent to it. And I think that's a real concern, but I think it's a concern at a different level. I think, maybe Tim might have more to say on this about what that means for the insidious creep of what people within the movement, people who were affiliated, who were not formal members, whatever membership may mean, how they feel about that listing. And, quite separate and apart from, what this means for criminal prosecution, I myself, I'm probably not so concerned that criminal prosecution will result for people who were adjacent to Samidoun, but there are serious issues for vulnerable people in the immigration context, in other areas where, short of criminal prosecution, is there a potential for surveillance? Is there potential for scrutiny? I think we have to be really concerned about that. So I'll leave it there for my comments, subject to questions.
Thank you so much, Yavar. I have on my list as Shane, you're next, but I'm not sure if it's Tim, because the email says Tim. So Tim, would you like to go ahead, or Shane, would you prefer to?
I'm happy to go after Tim, no problem.
Okay, thank you.
Sure. Yeah. No, I'm happy to go next. Thanks, Sara. And thank you so much to Just Peace Advocates and everyone who organized tonight's panel. And it's great to be here with Sara and Yavar and Shane. And thanks so much, Yavar, for that great kind of setting of the scene and the explanation of the case of Irfan. It's definitely a case that, as you explained and as we've seen, has had, repercussions over the years since that case happened. One thing just off the bat that I'll mention before getting into the specifics of the terrorist entities list is that in the last, I believe, 2 years, the government actually modified the laws around charities so that now, as soon as a charity is placed on the terrorist entities list, they're deemed to no longer have charitable status. So now they've just rendered it automatic. There's no need to go through a process. It's not that a charity can defend their status, but as soon as they're placed on the list, they're deemed no longer to be a charity, which means that they would first have to get themselves off the list in order to regain their charitable status. And of course, the justification for this is that, well, how could a charity be a terrorist entity? As soon as they're a terrorist entity, they must no longer be a charity. So I think that gives a good idea and a good segue into the actual concerns that the organization I work for and that I personally have around the terrorist entities list and why we want to join today's panel. So I work with the International Civil Liberties Monitoring Group. We're a coalition of 44 Canadian civil society organizations across the country, and we've been around since 2002. And we were actually founded explicitly in the wake of the adoption of Canada's first Anti-Terrorism Act in December 2001, after the attacks of 9/11, in recognition that there was this market increase and intense problem of these new laws being rushed in without study, and that we're clearly going to have significant consequences on civil liberties in Canada and internationally, and that it also coincided with increases in surveillance, increases in cracking down at the border and border restrictions, increases in racism and xenophobia and Islamophobia, and that there need to be a collective response. And so since 2002, the coalition has been working to advocate against the impact of anti-terrorism laws and measures on civil liberties and human rights in Canada and Canada's role internationally, both directly and also this idea that Canada somehow is a good player on the international stage, is a good example to follow. And so, we hear, talking with our international colleagues, that other countries look to Canada and say, well, if they have a terrorist entities list that operates in this way, that gives justification for our own use of these kinds of administrative measures. So one of the concerns that we've had since the beginning is that terrorism has been used to establish a set of laws that that essentially create exceptions to what's understood to be due process in the courts, what's considered to be protections around civil liberties, by creating this new category, as Sara, you mentioned, of terrorism charges, where terrorism is vague and is undefined. There's no consensus, and so it can be used in arbitrary and discriminatory ways. And one of those laws since the beginning has been the creation of the terrorist entities list regime. And so we have as a coalition have opposed it since the beginning, have called and continue to call for it to be revoked for a few reasons. And we issued a statement after the listing of Samidoun explicitly going into some of that. And essentially that, as we've seen over the past 20 years, that's an arbitrary and political tool that undermines freedom of association, freedom of expression, and due process in the courts. And moreover, its effectiveness as a national security tool hasn't actually been demonstrated in a manner that justifies its use. There's never been an independent review of whether or not it's an effective tool, but we do know its impact, as Yavar laid out, on issues around charities, but also its impact on freedom of expression, freedom of association, and the chill that it creates. I was going to speak a little bit about how the list works. Others have touched on, but just to say that, again, it's a secret and discretionary process. And as Yavar was pointing out, that it's a system where the government can consider any information, including untested intelligence. So the wording of the law is actually that they can accept anything, even if it wouldn't be admissible under normal criminal standards of evidence. And so, as Yavar mentioned, that's how secret intelligence from Israel or from other countries can be used in order to justify the minister's decisions. And then once it comes time to challenge the listing, it's nearly impossible because so much of the information is kept secret under security regulations. And I'll talk about that a little bit later because, in fact, in the government's rush to respond to foreign interference, there's actually been some changes to how the government handles these forms of secret. We don't like saying secret evidence, but secret information that they can use in these kinds of administrative proceedings. Sorry, I'm just catching up here. The other thing, and as Yavar pointed out, it also creates a situation where it's nearly impossible to mount a defense because it's impossible to raise funds. in order to pay a lawyer. There's been some statements by the court that a pro bono lawyer would not necessarily be subject to criminal charges for supporting an illicit terrorist entity because it's not the intent of the law, but we would be, and I think anybody who would step up to represent a illicit entity would be concerned about what the repercussions could be and how that could be interpreted by, by future governments or by, depending on who's presiding in the court. And I think it's also important to point out that there's very few Canadian organizations that are listed. There's Samidoun now and Irfan and some far-right organizations that ostensibly are based out of Canada, even though there's question about whether or not how performative that action was or substantial in terms of their activity in Canada. But the vast majority are not in Canada. And so it renders it even more difficult, if not impossible, for them to challenge their listing because they're not even part of the process and may not have access to being able to or be aware of the process for getting judicial review and filing a challenge. And it would also be very difficult for them to even be present in Canada, given that if they're a listed terrorist entity, they or their representatives would be barred from entering the country. And it also raises an important point about how historically the list has been used. So if we look at the organizations that are on the list, the vast majority are those that would be linked to what's called and so-called Islamic terrorism. And a disproportionate amount are actually organizations that the government would link directly to Palestine and Palestinian liberation. I think the percentage is about 14% of the organizations listed on the terrorist entities list are in one way or another linked to Palestinian liberation, and whereas they represent a much Palestinians represent a very small proportion of the world population, and present an even smaller proportion of of active organizations in Canada. And so this has been used to try to demonstrate, and has been used to justify this idea that the biggest threat to Canadians is so-called Islamic terrorism. Whereas we know that in the last 10 years, the biggest threat of violence, and that's led to the most deaths in Canada, and the largest threat has been from far-right extremists. And even though we have seen some of those organizations added to the terrorist entities list, that actually, from our research, hasn't really translated into a greater focus overall on that issue and that threat, but rather that it was a way to signal there was a concern, but to simply put them on the list and do very little to then follow up and address the issue. And so it's been used as a political tool, and we've seen the government and other governments that have these kinds of lists used as a way to deflect from the violence of the state and and problems with government foreign policy, and in order to justify a discriminatory and stigmatizing approach to what's considered a national security threat to Canada. The other thing that I wanted to touch on is also the chilling effect, as Yavar mentioned, and I think that was a really good point that you raised around how that the concern isn't so much around criminal prosecution. The risk is there, but we see this a lot around accusations of involvement in terrorism. So, for example, we've done a lot of research and work on how Muslim charities in general in Canada face greater scrutiny and accusations of being linked to financing of terrorism. Not once has there actually been a criminal charge laid of terrorist financing against anyone involved with a Muslim charity in Canada, but rather it's used to cause a chilling effect across the sector in order to try to limit and influence the kinds of works that charities are able to do, and to further Canada's foreign policy goals and the foreign policy goals of its partners, because as we know, some of these audits and the work of the CRA, as Yavar noted, and as we've seen in other cases, have been influenced by Israel and by other countries in terms of secret intelligence that's unfounded and untested. I think I'd like to just close up by kind of putting this in a bigger context. So we're talking about the terrorist entities list, but that's just one of the administrative tools that the government uses to try to combat terrorism, and that has these kinds of effects. So we also see it with the no-fly list, the Passenger Protect program, where people are placed on a no-fly list in secret. So it's actually even more, there's another layer to this one where without going to court, without laying charges, an individual is placed in secret on a list, limiting their ability to board an airplane. And they're only informed of the fact that they're on this list if they're actually barred from boarding, but they can be subject to a whole slew of other security measures, including interrogation, secondary screening, delays at the border, and things like that. Often it can result in people trying to return to Canada, then being delayed or being subject to the no-fly list, not being able to return to the country, or having to take a roundabout route in order to return to the country. And again, it's a system where once you are on the list, it's incredibly, and you know that you're on the list, it's incredibly hard to challenge your listing, because again, the information used to place you on that list is considered sensitive national security information and is withheld. And that leads me to the last thing I want to touch on around how this information is used in the courts and the changes with Bill C-70, the Countering Foreign Interference Act. And that's that. Along with the no-fly list, there are several other pieces of legislation that have these kinds of administrative regimes for countering terrorism. So that includes a new authorization regime for humanitarian organizations and international cooperation organizations that want to operate in an area that is controlled by a terrorist entity. So since last year, they have to apply for an authorization in order to carry out work for it. And the biggest example is in Afghanistan. There's also the Charities Registration Security Information Act, which allows for a certificate to be issued against a charity if the government believes that they're involved in terrorism or could be involved in terrorism. And what they do is they set up a system where there's these administrative proceedings, and where each of them had kind of an ad hoc system of limiting what kind of judges. Well, sorry, first of all, the Attorney General being able to say that information cannot be disclosed in court. The judge then having to review whether or not the information cannot be disclosed, and who's allowed to then have access to those proceedings around the discussion of disclosure. And if the information can't be disclosed publicly, what information is still going to be considered among that secret information in making a decision. And they were all kind of had different aspects that were similar, but also differences. And so under Bill C-70, they created what they're now calling the Secure Administrative Review Proceeding, to essentially universalize the process. It's going to standardize the process through all these different regimes. And on one hand, it gives a predictability to the system, but on the other hand, it creates essentially the normalization of the acceptance that when people are challenging these listings in court, listings that have an intense impact on their lives and on their livelihoods, that it's simple to institute a system where they can't have access to the information being used against them, and that they need to rely on the discretion of a judge, of a special advocate who isn't representing them but can hear information in secret, and of the government to be able to essentially represent their interests when none of them are actually there to represent the person or the organization's interests. And so our concern is that this means that it will be very easy going forward for the government to bring in new systems like the terrorist entities list and no-fly list and others, based on this idea that, well, now we have a standardized process for keeping this information secret. We don't have to worry about it getting out, so it makes it much easier to create a new system where this secret evidence is used. So that was a lot. I'll kind of end it there. There's a lot more that I think we could talk about, especially I think around the chilling effect on freedom of expression and what this means for the wider movement in support of Palestinian human rights and against the ongoing genocide. And hopefully in the question period we can get more into but yeah, thanks so much.
Thank you so much, Tim. I'll pass it on to you, Shane. Thank you.
Wonderful. Thanks very much. And I really appreciate being alongside Yavar and Tim on the panel tonight. My remarks are going to be more focused on addressing, I guess, this criminal intersection between listed entities, expression and assembly related to Palestine, and anti-Palestinian racism and the weaponization of allegations of anti-Semitism. So I'm going to endeavor to try and do this through using a Toronto case as an example, with a focus on efforts by the state to exploit existing legal frameworks to criminalize Palestine solidarity activism. But it's important to keep in mind that although I'm going to be relying on a Toronto case to kind of illustrate this reality, it's not a reality that's confined to Toronto. Police forces across Canada are collaborating with one another and with national state security agencies to attempt to monitor and repress what I think is undoubtedly one of the broadest and most sustained movements we've seen in decades. So I guess before we look at what the police are doing on the ground, first we need to look at how they are attempting to strategically concentrate on Palestine solidarity activists. In Toronto, this strategy is executed through the hate crime unit of the Toronto Police Service. The hate crime unit falls under the umbrella of intelligence services for the Toronto Police. And the hate crime unit was established back in 1993, and it was supposed to be responsible for collecting statistical data and ensuring the thorough investigation of hate crime offenses in the city. But what we saw on October 30th of 2023, as these historic protests in solidarity with the Palestinian people began to pick up steam, the Toronto Police Service significantly expanded the mandate of the hate crime unit, directing that it would do a number of things, including that it would be responsible for investigating and assisting and providing expertise to all criminal and non-criminal hate-related investigations, including occurrences related to what they called the Middle East October 7 conflict. They also said that the hate crime unit would have a mandate to investigate any arrest or occurrence generated as a result of protests and or demonstrations related to the Middle East conflict. So any occurrence does not mean any arrest. It is inclusive of any incident that comes to the attention of the police, essentially. So that includes, again, when we look at these two categories, the investigation of criminal and non-criminal matters. So this is significant because it means the hate crime unit is now responsible for investigating non-criminal activities resulting from protests and or demonstrations related to what the police generally refer to as the Middle East conflict or the Middle East October 7 conflict. Now, to the best of my knowledge, this is the first time a police service in Canada has openly given its hate crime unit an explicit mandate to investigate non-criminal, charter-protected political assembly and expression that is not hate-motivated in nature. And what came from this was a 500% increase in hate crime unit staffing in Toronto, going from 6 officers to a team of 32 members. And, given that this increase was not based on any kind of demonstrable spike in hate crime arrests from the previous year, this change also came with serious questions about what exactly is the primary purpose and justification for the expansion, leading many to suspect, or at least some to suspect, that it was to conduct widespread intelligence gathering on the Palestine solidarity movement. So this all takes us to this question of how does this play out in the streets? Now, there's many examples we could look at, but I'm just going to focus in on one for this evening, which relates to a listed entity on Canada's terrorism list. So in January of this year, a client of mine was criminally charged with publicly inciting hatred for allegedly flying the flag of the Parliament for the Liberation of Palestine, or PFLP, at a Palestine solidarity demonstration in Toronto. As some people may know, the PFLP, it's a secular and socialist organization with both political and armed wings. And it's designated as a listed entity by Public Safety Canada. There is no criminal law that states that it's an offense to fly the flag of a listed entity. But that didn't deter officers within the hate crime unit. They perceived some form of guilt by association seeing this flag being flown, and they were determined to act on it. And so in the face of this growing protest movement, which really sustained itself through the winter as well, they ended up manufacturing grounds for an arrest. And they claimed that somehow the mere display of this flag in public would incite hatred. The police also went on and unnecessarily publicized my client's name. And we learned many things through research associated with the case, including that the hate crime unit, it's working closely with many partners as part of this kind of interagency group that's known as the Hate Crime and Extremism Investigative Team. This includes collaboration with the OPP's political intelligence arm that's known as Project Hendon. It also involves collaboration with the inset teams of the RCMP and also with CSIS. And Toronto's chief of police was quite proud of this arrest. He made media appearances claiming that the hate crimes unit had collected evidence to support what he called an unprecedented charge. But he never disclosed what that evidence was. And the reason, it seems, is that the evidence didn't exist at all. After a number of months, it became clear that the allegations against my client were unfounded. The Toronto police were unable to provide any evidence that the display of the flag communicated a statement that incited hatred against any identifiable group. Nor could they provide evidence that displaying the flag was likely to lead to a breach of the peace, both of which are elements of the alleged offense. And the charge was ultimately withdrawn by the Crown. Now, there's a number of points that we can briefly distill from this. First, we see that anti-Palestinian racism is entrenched in the expansion of the hate crime unit's mandate to investigate what they call all Middle East related protests. The decision to do that, it has all the trappings of anti-Palestinian racism, which have been identified by the Arab Canadian Lawyers Association in their landmark report, Anti-Palestinian Racism. It criminalizes Palestinians by attacking and smearing them with this implied criminality requiring their demonstrations to be specially tasked by the hate crime unit. It imposes heightened risks of criminal consequences for those who mobilize in support of Palestinian rights. And through the involvement of the hate crime unit, it also paints Palestinians with this implied suggestion that they are anti-Semitic or terrorist sympathizers or opposed to shared national or democratic values. And see from this case and others is the police weaponizing broad allegations of anti-Semitism and hate in an attempt to increase the gravity of a relatively minor matter, or even in an attempt to criminalize non-criminal conduct. So in the PFLP flag case, there was not even an inkling of anything that could be considered hate motivation. But in the absence of anything else for the police to use to pursue their intended target, they made use of hate crime provisions of the criminal code, and they baselessly conflated an expression that was in favor of Palestinian national liberation with an expression of hate toward Israelis or Jewish persons. Their exact rationale was never explained to us. But what we do know is that groups such as Independent Jewish Voices have observed that the conflating of Jewish identity with the state of Israel and the conflating of criticism of Israel with anti-Semitism is problematic for multiple reasons. Among those are that this kind of an approach dehistoricizes anti-Semitism, and it also detracts from legitimate efforts to identify, address, and condemn anti-Semitism. And that actually makes Jewish communities less safe. And groups like IGV have also noted that this kind of action serves to sow fear that one might be accused of being anti-Semitic, and thus it silences any criticism of Israeli state action, including military action, when that kind of criticism is essential to calls for peace and preventing atrocities, including, as we're seeing now, instances of genocide. Third, and finally, we see that the state is actively exploiting both anti-Palestinian racism and the weaponization of allegations of anti-Semitism as a basis for the heightened surveillance of Palestinian rights activists. Police and other state security agencies, they're content to conduct widespread surveillance and monitoring of activists in the absence of any criminal conduct. And to rationalize this, these same agencies rely on manufacturing grounds of concern, which are often either rooted in anti-Palestinian racism, or they're somehow connected to false allegations of anti-Semitism, which are weaponized for political purposes. And it should be recognized that at the very same time as the hate crime unit's mandate was expanded by the Toronto Police Service, 4 UN experts expressed alarm at what they called the worldwide wave of attacks, reprisals, criminalization, and sanctions against those who publicly express solidarity with the victims of the ongoing conflict between Israel and Palestine. And so the hate crime unit's expanded mandate, it appears to fit within what these same experts from the UN described as a global policing trend, penalizes and labels pro-Palestinian protests as hate protests, and does that to preemptively ban them, and often cites risks to national security, including risks related to the incitement of hatred, without providing what they called evidence-based justification. So to wrap up, I'll reiterate what I stated when the charge related to the PFLP flag was withdrawn against my client, which is that the presumption of innocence has to outweigh sensationalism by the police whenever the police come out and announce that charges have been laid. The police and other state security agencies, they are operating in entirely new ways right now with entirely new technology that they oftentimes lie about possessing, and we only find out years down the road that they've been using. We have to remain vigilant in the face of this new era of surveillance that we're in. We have to remain vigilant in challenging violations of our civil liberties, and being, very vocal in, exercising our expression to criticize the police instances where we suspect them of overreach. We also have to continue calling out how anti-Palestinian racism is manifesting within these same agencies. We've seen it happen in the past and immediately post 9/11, and we're seeing it happen again in a new way right now that has many new. And so while these actions alone might not be sufficient to restrain the police criminalizing protest movements, they are unquestionably necessary parts of what will be a broader strategy of solidarity and resistance to repression by the police. So thank you.
Thank you so much, Shane, and thank you, Yavar, and thank you, Tim. As I prepare to go through and field some of the questions, fantastic questions from our listeners, I did want to start by asking, what are the ramifications of donors to charity institutions that have been charged or designated as an entity on this list? And what happens after your name has been removed in the case of Irfan Canada? Are there any public statements being made, or is this is the charitable status reinstated? Are there audits associated with that? So those are the 2 questions, and then I'm going to compile a few questions from our audience as well.
Maybe I can respond to the one around charities. don't know that I fully understand your question with respect to removal of the name. Your question is that once the charitable status is revoked, what happens as a result of that? Okay. So the first thing, the listing of the entity itself has prospective effect. So that means that the state cannot use it retroactively to criminalize something that happened the day before, the minute before listing, because no one knew that it was a terrorist entity. In fact, it wasn't, because it was only listed as of that moment. As a practical matter, and this was a question that we grappled with Irfan, because people were so scared about the fact that their books. I mean, the next day, the RCMP came to the offices of Irfan Canada, and they took their books and records. Their books and records were in any event transferred from Canada Revenue Agency to the RCMP. So all of those names and donors, that information was and is with the RCMP. Now, we did not hear that there were either interrogations or interviews or prosecutions that were initiated as a result of finding out that people had donated. But I guess I would raise, and it's not really answering your question, but I don't think that I just don't have the facts to say that there was criminal prosecution. But the implications, I think, could go to areas such as you're seeking security clearance, for example, with the government. You are opening a bank account, things where there are other, I guess, softer ways in which your reliability or security or for permanent residence, your legal right to remain in Canada can be scrutinized. So in those areas, I think it could come up. There was one case that I learned of recently, I wasn't aware of someone's affiliation with Irfan Canada being used as a basis to remove them from Canada. And that so it has come up in an immigration context before. So that's there too.
Thank you so much. We have a question. Are there legal frames to challenge these systems or lists? Are there legal frameworks to challenge these systems or lists? I think you sort of alluded to that, Yavar, about the difficulty of challenging this because you don't know what the evidence are.
I don't know. Shane, did you want to address that one or?
Well, I think you did hit on it, Yavar. I mean, there are processes where there's kind of the delisting process that you can go through with the minister. So in other words, applying to have a group delisted by the same minister, sometimes that may have been the one to, lead the charge to have the group added to the list. You can imagine how successful that may or may not be. And then there's a question of going through federal court on a judicial review of that decision as well, right? So there to go about it. However, hurdles that are there, including such as
there might be a lag. Sorry, Shane, you cut off towards the end there. We didn't.
My apologies. Having some connectivity issues, but it's I was simply noting that it's a very uphill process, whether it's applying to the minister or going by way of a judicial review. It's definitely a presumed guilty until proven innocent approach.
Thank you.
And if I can add to that, the onus is on the entity to apply for delisting, and it's on a standard of you're challenging a ministerial decision based on reasonable grounds to believe. So the difference is the minister lists because they think that there's reasons, and it could be as simple or as flimsy as guilt by association. Essentially, they list. The onus comes back on the entity to apply for delisting. That gets, as Shane is suggesting, probably will be confirmed, and then you have to go to challenge the reasonableness of that low standard by which the minister justified their decision to begin with. So it's an uphill climb. It's a difficult one, in particularly because anyone who could be engaged, and we tried to do this, has to do so for free and has to sort of go through a very circuitous process to get there finally.
And if I can just add, correct me if I'm wrong, but I don't think that there's been a single, individual, because an individual can be listed, or organization that has successfully challenged their listing and had themselves removed. The government reviews the list a listing every 5 years, and there's been a handful, I think, of groups that have been removed, usually because they're defunct, not because they're no longer considered a terrorist organization. So, for example, the FARC in Colombia is still listed as a terrorist entity in Canada, despite the fact that it's now part of the collective peace process in Colombia and the reconciliation and truth process there. And yet, an individual who was or a member of FARC or is currently affiliated with that process could be deemed a terrorist in Canada and denied entry to Canada or subject to sanctions.
Thank you. That kind of goes with this excellent question. Are there any examples outside Canada where social movements, public pressures were able to get state security agencies to abandon a listing or the list entirely?
Maybe that's a really good question. I don't have universal knowledge around whether or not this has ever happened. What I can say is that there's been studies over the last years that these types of administrative counterterrorism laws are proliferating at an even greater pace. So there may be instances where people have mobilized to undo some of the negative impacts or to rescind these kinds of laws. But in fact, what we're seeing is that more and more governments are turning away from using the criminal code, where charges need to be laid and evidence presented, to using preventative administrative proceedings in order to list people, in order to deny them access at the border, in order to block them from accessing funds. There's a really great report that was put out by the previous UN Special Rapporteur on counterterrorism and human rights, on the impacts of counterterrorism laws on civic space. And I'll put a link in the chat, and I'm not sure if we can share that with everybody, but I'll look it up. And maybe it can be shared afterwards. And the new special rapporteur is actually looking to engage in a study internationally on this, but it's certainly a growing concern, and we've seen it, in Israel, in India, in the United States, in Germany, in the UK, where these lists are proliferating, and the use of administrative tools to essentially create these kinds of chills on dissent and freedom of expression are being used in the name of countering terrorism and protecting national security.
Thanks. And I think we've seen an exerted effort to try and add UNRWA to that list recently, which was quite scary. We have a question about Samidoun specifically. Is there any, I don't know if any of you can comment on this, but are there community efforts to advocate for Samidoun, or at least to get them delisted, or some kind of effort in that regard?
I mean, I believe there are efforts happening. I'm not closely familiar with them, but I believe there are efforts out there, solidarity campaigns to try and support the delisting of the group. It's a difficult situation now, right? It's an extremely sensitive situation, and that's what the state wants. They want people to be apprehensive. You kind of you cut at the heart of these groups, right? Is through this listing process and making people nervous to get involved with any kind of efforts or speech around trying to think critically and encourage discussion about the listing and whether it should have happened in the first place. So I think there are things underway, but there's challenges with those as well, right?
We have a question about advocacy to place an entity, I guess, on the list in this regard. Can Palestinians in Gaza, West Bank, East Jerusalem, or can Canadians petition the Canadian government to list the IDF, for example, the pager attacks that would constitute under Canada's own very vague definition of terrorism as a terrorist attack? Can civil society participate in this process?
If I can respond to that one, this is my position specifically, and I don't know what my co-panelists think. I just think it's very dangerous to, politicize what is already this very politicized listing process even further, because essentially where other groups who are rightly, the subject of terrorism, violence, genocide, whatever it is, from these odious groups, by listing them, it just legitimizes the list themselves. And I think that when we're looking at, for example, with the JNF, it's the recent confirmation of the revocation of charitable status. That's an administrative process that can be challenged. There's an adversarial process to deal with it, but it obviously hobbles its ability to do what it's trying to do. So I think there's other measures to address the problematic nature of some of these charities and organizations. But for me personally, it's a dangerous thing to enhance the legitimacy of the list by advocating for more organizations to be listed.
I would concur with Yavar on that. It's going to the same state that is leading this kind of racist, repressive campaign and asking them to help, right? In some way, right? In this kind of broad sense of the word. Yeah, I mean, the pager attacks, they were terrorism. I mean, even Leon Panetta, the former director of AA, came out and described them as such. But I think that there's ways for us to organize without having reliance on the state and trying to use these highly problematic systems.
Yeah, we have a few questions about, the extent of like social media posts being used. But Tim, sorry, I didn't mean to cut you off.
No, I was just going to say I agree completely, and there's also the issue that just the likelihood of such a campaign resulting in the government listing of foreign military, even though the IRGC in Iran is now listed, and that's actually raised a whole slew of concerns that people who are conscripted into a military service and may not have participated in any, and may eventually be conscientious objectors or then go on to oppose the state would actually still be considered members of a terrorist organization. So it can have these knock-on effects. And also there were several organizations, including groups in the Muslim community, who opposed, several years ago when the list was being used to list white supremacist organizations under the basis and the recognition that, as Shane was saying, that the government may now be symbolically adding some of these groups, but the vast majority of the groups listed and the ways that it's used and will continue to be used is going to be in these detrimental ways, and that we can't trust also, even if you were to place your trust in the current government that they are acting for the right reasons, that the next government wouldn't use this as justification to continue using the list in ways that we've been fighting against. Yeah. So sorry, Sarah, I didn't want to interrupt that.
No, I apologize. I interrupted you. We have several questions about social media posts being used as grounds to constitute terrorism or be designated as such. And someone wants to know a little bit more about the Toronto Police Service's Project Resolute.
Yeah, I mean, Project Resolute, what is, there's a lot to say. It has, it is the eminent example of I think, this, we'll say intersection again of anti-Palestinian racism and the weaponization of allegations of anti-Semitism. Are there acts of anti-Semitism in Toronto? Absolutely, there are. Is anti-Semitism a problem? Yes, it is. Like other forms of bigotry and discrimination and hate, of course. But what we see here is the exploitation of it by the state for political ends. That's the issue here, right? We see the term being misused and misdirected at people solely for being critical of the Israeli state, right? And that's where things highly, highly problematic. And that's a characteristic that really defines much of what Project Resolute is doing. I mean, the hate crime unit through Project Resolute, they have gone out and got nighttime warrants to raid people's homes because the person was suspected of recording a demonstration, recording a Palestine demonstration using a drone, right? And the demonstration was considered to be an illegal assembly. And so the hate crime unit was tasked with that. There was nothing remotely hate motivated about it, right? But it's this general veneer that's put over everything when the police come out and they say, the hate crime unit has made arrests, the hate crime unit has, executed warrants. Well, when the public hears that, they immediately think, oh, there's hate motivated activity and it's associated with these protests. There's a reason why they're tasked with doing this, right? Apart from the larger intelligence objective behind it. Yeah, we see it over and over and over again. It's an extremely problematic project that the police are leading, and I think it's doing a great deal of harm to the community and also to the legitimate battles that are out there to combat anti-Semitism, as has been noted by independent Jewish voices and others. This is a very kind of troubling expedition that the state has gone out on, and it's for very political purposes. And I think time will reveal that more and more as these cases work their way through the system and more information becomes exposed about what is really going on behind the scenes with the police and the Crown's office. We're going to get a much clearer picture about what are the definitions that are being used by the police when they're investigating and classifying particular types of offenses. What are the agendas and the objectives and the goals of these projects that they're leading, and also what is the degree of surveillance that is being conducted on attendees, families attending protests. I think we're going to be learning a great deal about that as well. That's going to trouble a lot of people.
Someone is asking if the process itself, if the act itself can be challenged. And we have a few others that are making broad linkages to the laws being mobilized in the UK, in the United States. So clearly there's some discussions that are perhaps in unison globally. So can the process itself be challenged? And is there a cohesion in these lists on a global scale, which I would argue, yes, absolutely.
I have some thoughts on that. I think that there are listing regimes and the ability for ministers to make reasonable grounds to believe assessments for security decisions. Those have been upheld, and I'll tell you, in a different context, and in an immigration security related context, I dealt with something called a security certificate, where there are these, the use of what's called ex parte or secret information that becomes the basis of listing for detaining someone in an immigration context. And that process went to the Supreme Court on 3 occasions, and it was always upheld to be constitutional, with tinkering with the process by allowing for procedural safeguards. And there's a few clever things that the current listing regime does. For example, I mentioned the fact that you can not get around, but you can get permission from the government to be able to give money to the entity, but the Attorney General won't allow it. So there are what are called safety valves that are built into the process. And I think that's done intentionally so because the listing is so onerous. Another thing that's problematic about it, but it sort of goes back to the reasonable grounds and the fact that an initial decision is made, on this, very flimsy reasoning. The minister might not have any, firm evidentiary basis to make that original decision. And in part, it might be just about guilt by association. But that guilt by association for a group, for example, like Samidoun, which is just about prisoner solidarity, networking, pro-social activity in terms of Palestinian solidarity, um, can nonetheless be sort of perversely, become the basis of a listing, and you have to challenge that after the fact. So it's not that you can't challenge that perverse decision. It's really hard to do it. It's really onerous to do it. And at the end of the day, I think there's a lot of things that are problematic about the listing. But I think that the mechanism itself is tough to. I'm not saying that it can't be brought down, but there's clever ways that have been put into to build safeguards into it.
Thank you. Would anyone like to field the question about different nations kind of working together to have similar lists?
Yeah, sorry, just a question, is that they're sharing information to develop these lists? Is that the
Yes,
question?
so we have a question from UBC Encampment and two other audience members that are asking more or less a similar question.
For sure. Maybe just to say that we know that Canada, especially with the Five Eyes nations, so with the UK, the US, New Zealand, and Australia, but with others, including Israel and India, more or less to a certain degree, maybe less so now with the recent developments. But they do share a lot of intelligence information, and they do share these kinds of lists with each other, and the kind of information that's the basis for these lists. And so, for example, especially with the United States, we know that there's an intense amount of information sharing. We know that there are secret lists. So the tip-off U.S.-Canada list, which is the list of I believe more than 200,000 people who are considered to be either involved in or associated in some vague and guilt by association way with terrorism in the United according to the U.S. government, is shared with Canada in order to monitor people entering the country, and to either deny them entry, declare them inadmissible, or to subject them to secondary screening, put them on no-fly lists, and things like this. So there's been efforts to push back against this kind of information sharing. One of the areas where we have seen some success in the last few years is around instituting limits and safeguards on the sharing of information that may either be the product of mistreatment or could lead to mistreatment if shared. So information gathered under torture or other under forms of mistreatment. It's not, it's far from perfect, but it's much stricter than it has been in the past. But part of the problem is that it's based on the ratings and the ideas of which countries engage in mistreatment. And so, for example, we know that the US is considered to not engage in mistreatment, even though we know there's mistreatment in their prisons. We're not sure about where Israel is listed in, or is considered in the categorization of countries that engage in mistreatment, and whether or not the information that would be shared by the Israeli government would be considered excluded under these kinds of directives. So there's still a lack of clarity, but it is reviewed on a regular basis by the National Security and Intelligence Review Agency, on an annual basis, in fact, for compliance. And so there's at least some sense that the worst forms of information are not, and that could cause the greatest harm, are being limited. But when it's secret intelligence, when it's untested, when we don't know the provenance of it necessarily, it could be coming from those kinds of areas and still make its way into the decision making around the terrorist entities listing and others. So there's a lot of work that still needs to be done, but certainly countries talk. They talk a lot. The Five Eyes do in particular, but in general, there's a lot of information sharing between countries that go into how these lists are made. Yeah.
Mhm. And it's beyond lists. I was involved in a trial where there was some CIA stuff that became, remarkably discovered by CSIS in interesting ways, and regarding some Iraqis seeking refuge in Canada. And by our shock, we discovered that CSIS has information that the United States. Anyways, it's a big abyss, but I don't want to keep our panelists any longer. We're supposed to let you go 3 minutes ago. I just want to thank you very much for your time and your expertise and enlightening us, and hopefully we will have better conversations in the future. Karen, would you like to offer some concluding remarks?
Just to say thanks to all the audience being here, and we will have the recording out to all those that registered, and it has been live streaming on the Just Peace Advocates YouTube. And thanks also to Canadian Foreign Policy Institute for working to get this put together. And thanks so much, Sara, for moderating, and to the panelists, Tim, Yavar, and Shane. Thanks, everyone. Good evening, good afternoon, and thanks so much. Bye.